estate of Richard Omar Myatt in the corollary case of Michael Andrew Betts versus Janie Eudora Myatt. So I am ready to hear the motions. There's, I think, a motion that you filed first on behalf of your client, correct?
Judge, yes, Your Honor, and we anticipate having testimony. Judge, this matter was before the court on August 1st, 2024, and it came before the court for the purpose of trying to get in contact with DDC Testing Company. That did occur as far as, scheduling a call with them, but prior to the call, they requested that if there were additional relatives that could be tested, that those folks be provided if we could. So, Judge, for a time period, we tried to work on, as my understanding, Eugene Myatt, another brother, was willing to be tested, but as it came to pass, we never could get that done, completed, and I'm not sure, I never was given an exact reason why, but as that developed, Judge, we, as the court allowed, have retained what we believe to be an expert in the field. We would submit the witness as that. The court will hear from Dr. Jennifer Below, and she rendered her opinion as to the findings of DDC and their report.
So that we're clear on what we're doing today, having heard testimony in the past in this case, today's hearing is for a final determination then of whether or not the Catherine Rundle is or is not the biological child of Charlie Myatt, and therefore would be entitled to share in the estate of Richard Myatt. Am I correct on that?
Judge, that is one of the requests, and alternatively, you're going to hear proof and that additional testing could be done that would, with the existing DNA samples, further testing that could, as I understand, I think the testimony would be, with 100% clarity, provide direction to the court. And so that will be before the court. I'll let the testimony speak for itself.
I just wanted to make sure that was at least one of the issues, but your argument, are you asking for additional testing? Is that
Judge,
right?
I am, as part of the as part of an alternate argument, a request. And the reason being is because, again, I believe this is a search for the truth. And certainly, from a standpoint, we do not believe the current test as they stand now, we believe says that this person, Kathy Rundle, is 91.5% not related at all, I believe is what the testimony will be. However, there's 8.5% that she may be. And so if the court is looking for absolute clarity, that's why Dr. Below would testify that with the existing DNA that DDC has on file, they are should be able to do additional genome testing or genotyping that would provide clarity. And she will provide an explanation as to that.
Right.
But however, our argument as well, Judge, is that there is sufficient proof in the record to show that she is not a relative. She is 91.5%. As someone said, if you were going to take a plane flight and someone told you there's a 91.5% chance of this plane crashing, would you get on it? So, Judge, we're here. We'll leave it to the court's discretion, but yes, we are asking for additional testing based on what our expert will be able to testify and show.
All right. Knowles?
I have previously filed a motion for the court to declare Catherine Jean Myatt Rundle as an intestate heir of Richard Omar Myatt, and Your Honor has heard proof. We put on proof, then Attorney Vandervoort put on proof. The proof was closed, and then the court ordered this DNA testing. The DNA testing was complete, and counsel has made a lot to do of the 91.5%. with that in thought, we were testing aunt and uncle against a child of a deceased sibling. So what the test results actually say are these results do not provide sufficient evidence to support or refute the tested relationship. So I submit to the court that these DNA testing, it just did not provide any more clarity. But the proof that you did hear, of course, was from the family members, from Miss Janie Might, who's visited with the child in the home of the parties, who knew they traveled for 2.5 years with the carnival and lived as a family unit and then took care of her brother. So, Judge, I would ask that Your Honor rule on the proof that you've heard and let this case move forward, as the DNA testing can just continue forever, I'm afraid.
Anyone else have any statement they want to make? I know there are other parties involved.
Your Honor, again, the only issue that I just want to make the court aware of is what I was under the understanding. My client submitted her DNA for testing.
You represent Janie,
Yes,
is that
Janie.
correct?
Mhm. And so when we came back to court after we got the test results, and we had this hearing, I understood that counsel for all the parties, that Mr. Vanderbilt was going to coordinate a conference call so we could all question the lab technician, the scientist who did this, as to what to extrapolate and tell us, to explain the report to us. That was never done. I get that Mr. Vandervoort and Ms. Franklin, who is the guardian ad litem for the other living sibling, had some conversations about having him tested. And so that kind of went on for what,
Him being,
5 months.
who is him?
Henry Eugene. Miss Janie, Mr. Sam, and Mr. Henry Eugene are all the living siblings of the decedent. But again, we just never, none of the attorneys got together to discuss with the lab. The expert that I assume that in my conversations with Mr. Vandervoort, who is here, is not from the testing agency. It's an expert that Mr. Sam Might has retained to discount the test results. So my only situation is that I just wanted the court to be aware that I never participated in a conversation that the court ordered to be done.
Go ahead. Officer, could you hand me the remote?
After the last court date, Mr. Vandervoort asked me if Mr. Henry Eugene would be willing to give his DNA sample. I went.
And you're the guardian ad litem for him?
I am,
And the reason he has a guardian ad litem is what?
due to his advanced stage, and
How old is he?
believe that at this point in time, he's 94.
94 years old.
And he currently is at his house still. He does not leave his house, which creates a difficulty with scheduling and coordinating his ability to give his DNA. He was willing to do so whenever I met with him. However, it's a coordinating effort, and I spoke with Mr. Boyd from the testing agency because he was the one who was going to come and do it. And he informed me at that point in time that everybody would have to be retested. And I think there's just a disconnect in communication here as to, is everyone required to be retested? Is that outside of the order of the court? And we did never actually communicate with the expert from the testing agency that we were supposed to. There were some emails exchanged to try to schedule it. I think that we all gave our availability and tried to schedule a day, and that just never came to fruition.
All right. You may.
Again, for clarity, the conference call was scheduled on October the 30th. About 15 days prior to that is when DDC, the staff, the coordinating agency got in contact with me and requested if there are others out there that can be tested and are willing to do so, We would like to have that as officer of the court. I'm representing this to the court. We would like to have that person tested. And so, but yes, that's when, in fact, we got in contact with Ms. Franklin. Ms. Franklin indicated that he was willing to do so, and that's why it's been 4 or 5 months. And Judge, so
Well, let me ask this question, and this is generally for all of the council involved. When I first broached the subject of having additional or DNA testing done, it seems to me that, and when there's additional testing to be done, like in a paternity testing, they show up at a lab and they give a sample, and a record is made as to who that individual is. The problem is, with the advanced age of Mr. Henry Eugene, that's not probably practical, but I'm trying to determine exactly how it would be done, that additional testing would be performed, and if so, how long is it going to take to get it done, and so forth. I mean, we have a DNA test done on Miss Rundle right now. It shows a percentage that says she is related and a larger percentage that does not show a relation. So my question is I also have additional proof that was testified to at the hearing. I'm willing to give opportunities for anybody if there is a consensus that additional DNA testing can be done, but it's going to have to be done in a fashion that can be expeditiously performed, because obviously we've got one individual who's 94 years old. So,
Judge, if I could address that. So, again, it was coordinated and it was explained that there would not have to be any other testing, new additional testing to those individuals. The existing DNA from those that provided DNA could be tested. My understanding is it's no more than a swab.
that's what I've always understood. So.
With that, Judge, secondarily, Dr. Piper is prepared to testify that, based on her experience in testing DNA, the 3 that have tested, that have provided DNA, that DNA could be further tested out and just tested. Make a determination. So we've got 2 opportunities for this to occur, to give the court's looking for absolute certainty. That's where this sits. And Judge, for me to tell you exactly, there was not going to be any charge by DDC for obtaining the additional DNA from Mr. Eugene and going forward and testing it at the lab. They weren't going to charge any additional money. I provided that to counsel.
All right. Well, let's let you put on your proof, and I'll figure out what I'm going to do.
That's correct.
There was a scheduled one, but it didn't take place.
That's all I was
I
saying.
understand.
None of us participated in it. Although coordinated and promised. That just never happened. Mr. Vanderwood is exactly correct in saying, I just wanted your honor to know that that call never took place. Now, as to whether or not they needed it.
That's correct. They asked for it. It was available.
I'm going to turn your microphone on the table on or come to the podium.
Yes, sir. We've already actually hashed some of this stuff out in the last order when we were here on August 1st. The court actually ordered, the court does not order any additional testing. The court is simply authorizing counsel for the parties to have access to contact the diagnostic center. That's paragraph number 4 of your prior order. So this additional testing is all outside of the scope of what you've already ordered. And 5 goes on to say that, yes, Mr. Vanderbilt can have his expert here to testify about the test that we already have, the interpretation of that test. So I just submit to the court that this is outside the scope of that prior order, and that whatever the witness testifies today to, should be limited to review of that DNA test that we already have conducted. And that's just paragraph 4 and 5 of your August 1st, 2024 order, which was filed September 13th.
All right, well, I'm going to let Mr. Vanderwart put on his proof, and then I'll make a determination as to what, if anything, needs to be done additionally, so.
May I just,
Yeah, go ahead.
it's a little bit disingenuous to stand up and say that basically that there was no one aware of this requested additional testing by DDC. Mr. Knowles was aware of the testing because he provided the name of the person that was going to go and collect. And Judge, certainly the only reason it was requested of counsel of all the parties, is there anyone else, is because DDC requested it. If any of the parties would have said, no, I'm not agreeing to do that, then we would have proceeded, Judge. So like I said, it was scheduled. But Judge, that's really not why we're here. Why we're here is trying to, yes, we are asking for additional testing to occur, and there's 2 opportunities and ways to do it. Beyond that, yes, sir, I guess the court can make a determination on it as it stands.
All right. You are the moving party, at least at this juncture, Mr. Vanderwart, on your motions, so let's go ahead and let you put on your proof.
Judge, I'd call Dr. Jennifer Below. She's out in the hallway. I'll step out.
My name is Jennifer Elizabeth Below.
Dr. Below, what is your current job title?
I am the director of the Vanderbilt Genetics Institute and a professor of medicine at Vanderbilt University Medical Center in the Division of Genetic Medicine.
And again, is that your chosen field of study?
Yes.
Okay. And I want to hand to you what you have provided and I've provided to counsel, which is your.
All right, and we're stipulating that she is an expert in what field?
In genetics.
Genetics, all right.
That,
She will be classified as an expert in the field of genetics.
thank you, Your Honor. Dr. Below, are you currently teaching?
You want to go ahead, was that her CV?
Yes, Your Honor, I'd like to make that
Let's
an
go ahead
exhibit.
and make it an
Yes, sir.
exhibit.
You'll hand that to them.
Oh, sure. Yes, I do currently teach.
And that is, you're teaching, tell the court, explain to the court a little bit about what you're teaching.
Sure. As the director of the Vanderbilt Genetics Institute, I oversee our Human Genetics PhD program and all of the curriculum within the Human Genetics PhD program. I personally teach several classes on Python programming for genetic data analysis. But the primary objective of my research group is to conduct research within the space of human genetics for the purpose of understanding the genetic causes of human disease.
Okay. And specifically, do you have experience in genetic testing?
I have a lot of experience. I might be considered a global expert in relatedness. Some of the statistical tools that I have developed have been utilized by companies that are conducting genetic testing. In fact, I learned about a year ago that the algorithm that was used to identify the Golden State Killer was based on my algorithm.
Okay. Were you asked to review the DDC DNA report dated April the 12th, 2024?
Yes, I was.
And was that as to certain genetic testing between an aunt, an uncle, and a potential child?
Yes.
I hand that to you, the DNA test. Is that, recognize that?
You
Thank you. Yes, this is what I looked at before.
Judge, I'd ask that that be made an exhibit to her
Can you hand
testimony.
this to you too?
Look at his Exhibit 2.
If you'll keep that in front of you as well. Dr. Below, Did you review DDC's website as far as their genetic testing?
Yes, I reviewed information that was provided on their website and also compared that to some of the results that were found on the report.
Specifically as to avuncular testing.
Yes.
And what is avuncular testing?
Avuncular testing is testing the relationship that would exist between an aunt and uncle and their niece and nephew.
Okay. And do you recall what their website provided as far as avuncular testing and as far as what a index response range would be?
Yeah, so I believe that in response to a question from a user asking about a grandparental relationship, which actually shares exactly the same proportion of DNA as an avuncular relationship shares, that the exclusion range was below 9% as a percent likelihood of relationship given the relationship compatibility index.
Okay. Below 9%, the relationship would be excluded.
Would be excluded, yeah, per this site on their website.
Okay. As a result of your review of DDC's report, did you form an opinion and also put it in writing as to the content of their report?
I did. I wrote a summary of their report and provided that to you. I believe that the report indicates that there's an 8.5% chance of relatedness in this case and a 91.5% chance of unrelatedness in this case, which per the website would classify as not related.
Okay. And in your expert opinion, is that accurate?
Yes. The presence of alleles being shared between individuals is common to observe because human genomes are largely similar to one another. What we look for when we're looking at genetic relatedness testing and building pedigrees or family trees is for there to be an excess of sharing above and beyond what might be expected by chance. And so these probabilities are derived from a comparison of the amount of genetic material that would be expected to be observed by chance compared to what would be representative of an excess of sharing due to relatedness. And this indicates that there's a very low likelihood that the amount of sharing that is observed is due to relatedness. It's much more likely that it is due to chance.
So when you say due to chance, what do you mean by that?
Yeah, so as I mentioned, humans are largely genetically similar. We have different we have sites in our genome in which some people have potentially one type of content, somebody else might have another type of content at that site. Those are variable regions. The variable regions have different frequencies. So for example, you might be thinking of the A, G, Cs, and Ts in the genome. So if you have a site in the genome where 99% of human beings have the A variant, and then you have two people that have the T variant, it would be more likely that they would share that T variant because they are related, because it's a very rare thing to observe. Whereas if two people share the A variant, it would be very likely that they share it just by chance because 99% of all people have that variant. And so without having the frequencies of which these alleles that were used in this panel at my disposal, I could actually then confirm and validate their calculations. I don't have those frequencies, so I'm not personally able to confirm and validate their calculations, but their values are derived from that information. What is the likelihood that the patterns of sharing that they've seen in these DNA tests is due to chance versus is due to relatedness?
So I want you to take a look at Exhibit 2, which you should have. Judge, and I have an extra copy of the court.
I have Exhibit 2, but does she need to look at it?
Yes, Your Honor.
All right, then let her have the exhibit, and I'll take your copy.
Thank you.
So in Exhibit 2, it says the combined relatedness index is, what does it reflect there?
It says here that the combined relatedness index is 0.1012.
Okay, and then that paragraph underneath it, it continues to read, based on testing results obtained from the analysis of the DNA loci listed, the probability of relatedness is 8.5, and you've testified to that. The likelihood that the alleged related relatives are not the biological relatives of the tested child is 10 to 1. What is your understanding of that?
that means that if you were to look at this scenario 11 times, in 10 of those cases, there would be no relatedness between the individuals, and in 1 out of those 11 chances, there would be some relatedness between those individuals. And that corresponds to that probability of relatedness being 8.5%.
Does that correlate to it being by chance, though?
It correlates to the likelihood that these individuals are not related to each other being 91.5%.
Okay. And specifically, the reason I ask you to cite to Exhibit 2, your earlier testimony, the calculations, what does that next sentence say?
It says this probability of relatedness was calculated by comparing to untested, unrelated random individuals of the Caucasian population, assuming a prior probability equals 0.5.
So that was part of their calculation, which you had testified to would be considered.
Yes, so they're saying that their prior probability that there was a relationship to be observed here was a 50% chance, and based on their calculations on that prior probability of 50%, based on this genetic information, that probability has been reduced to 8.5% chance that they are related and 91.5% chance that they are unrelated.
When you say unrelated, are you talking about unrelated at all?
Correct.
So, okay. What amounts of genomes are expected to be shared between a parent and a child?
A parent and a child share one chromosome for every chromosome identically by descent, so they share exactly 50% of their genomes.
And for an aunt and uncle and a niece?
That would be 25% of the genome would be
Okay.
expected to be shared by chance. Or not by chance, sorry, but would be expected to be shared due to that relationship.
Okay. And that is not reflected in this report?
I would expect that, given that we would expect 25% of the genomes to be shared among an aunt and a niece, that the likelihood of observing a higher proportion of variants to be shared would be, that would be my expectation, yes. This does not seem consistent with me, per the report, that they are, in fact, avuncular.
Okay. Avuncular meaning, again?
Aunt, uncle, niece, nephew.
Okay. Is it fair to say that testing anyone here in this courtroom could result in an 8.5% probability of being related?
Yes, because the likelihood of humans sharing variants is not, humans share many of these alleles just by chance and not due to relatedness. This amount of sharing is not far above what would be expected by chance of any two random strangers. In
I'm not
fact,
sure I understand, but let me ask this question. So if I had everyone in this courtroom tested, you're saying there would be an 8.5% chance that Mr. Vandervoort and Ms. Roberts would share DNA?
that's not quite right. I'm saying that
I've long suspected there might be something there. I do not mean to make light of it, but I just,
no, I understand. So on average, individuals share 99.99% of their genomes. So the handful of sites in the genome that vary among people are some of which are being highlighted here. So we expect to see that based on the frequency of those variants, again, if some of these markers, they're represented here as numbers, those numbers correspond to the number of repeats of a particular segment of DNA that are seen. So, for example, for the first variant, the alleged child has the variants seen 14 times on one chromosome and 15 times on the other chromosome. The alleged aunt has a variant where it's seen 15 times and 18 times, and the alleged uncle has the variant seen 18 times on both chromosomes. And so they've looked at the frequency of how often people have the 14 times versus the 15 times in their genome, and they've used that information to calculate how likely it is to observe this amount of genetic sharing by random chance, meaning any two people that you might draw from a population, and compared that to the amount of sharing that you'd expect to see if two people were related with the degree of relationship that's shown here, which is avuncular. And they find that there's 91.5% chance that these two individuals are not related, that this does not result in an excess amount of genetic sharing that would be reflective of this relationship.
Dr. Below, You have on page 3 of your report, and Judge, I have an additional
Yeah, I was going to say, I do not have the
for
report.
the court. And if I've circulated this to council, so everybody below you.
Thank you.
I'll give you a moment to orient yourself to that report. Is that your report dated May the 2nd of 2025? And in fact, you are making reference to the markers. If you'll turn to the last page, it should be in color. The left-hand side of table 1, are those the markers to which you're referring?
Yep, that's correct. And here what I've done to help illustrate for people that might be new to this is where we observe a marker that is shared and where there was some question that I had about the specifics of the calculation that the company performed to provide information that might be useful to help interpret this result.
So that's what your table is reflective of.
Yeah, my table was colored in order to just help clarify for people that might be less familiar with looking at these kinds of results, what we were seeing.
And then figure 1 up above that, that just demonstrative of the relationship that you were trying to.
Yeah, that's correct. So this is a commonly used form of representation of a family tree that we used in genetic analysis, where females are represented as circles, squares are represented as are representing males, and you can see that the A and B are representing potential grandparents in this case. D, E, F, and G are a sibling quad, and then we have a hypothetical relationship between the deceased member of the pedigree D and the child H. And I've noted with some little speckled marks the people that were genotyped in this case.
Based on your review of this, does it change your opinion as to the 91.5% that was reflected?
No, this is actually very consistent with that. So I didn't observe any specific genetic variants that were fully inconsistent with any possibility of transmission. And so that is reflected in what the company has reported, that it's not 0% chance of relationship and 100% chance of being unrelated. If that were the case, I would expect to see those numbers. So the results that are seen here, in my opinion, are very consistent with what's reported by the company DDC.
But again, on their own report, on their own website, it reflects 9% or below it's excluded.
That's correct. So the likelihood is considered so low that you can exclude the possibility of relatedness per their website.
So I want to look at your report, page 1 of your report, if you will, bottom of the page. In fact, you have, I believe, have testified to this, but I just give the court, if you will, your summary of that last paragraph on page 1.
Yeah, if it would be helpful. So this is reiterating a lot of what is already stated in the DNA test report, but here I noted that this DNA test report shows the particular variants that were measured at 29 different locations in the human genome, and that these were measured in the child, the alleged aunt, and the alleged uncle. I noted here that when a single number appears in this DNA test report, that's reflective that the company observed homozygosity. Another way of saying that is that both chromosomes had the same variant observed. The DNA test report here also reports an RI, or relatedness index, for each locus, and this is a measure that's derived from the population frequency of the alleles shared between the child, alleged aunt, and alleged uncle. And the report also shows a combined relatedness index score, which here is shown as 0.1012, and this is an aggregation of the evidence across the loci. The report indicates that the probability in this case of relatedness is 8.5%, and that the likelihood that the alleged aunt and uncle are not biologically related to the child is 10 to 1.
Okay. I want to turn to the last page of your report. Mm-hmm. And specifically to that last paragraph.
Yeah.
second sentence talks about genotyping additional variants in the DNA samples already collected from these individuals can also provide the desired information with high confidence.
Yes.
Tell the court to what you're referring there.
Yeah, so with all due respect to the court, you guys are using old technology. The modern genomic analysis would involve the genotyping of potentially thousands, hundreds of thousands, or millions of variants across the genome, and this is actually extremely inexpensive and affordable. You can run a test that has 2.6 million variants on it for about $85, $86 per sample. And so in my field, where we're actually using this kind of information to reconstruct family trees and then follow the transmission of disease through a family tree and try to map the causal genetic variants, we use this sort of dense genetic data all the time. And with that sort of dense genetic data, we would be able to preclude any, decide with 100% likelihood whether or not this truly is an avuncular relationship without needing to sample any other additional people, just by doing a better job of characterizing the genomes of these 3 individuals that have already been genotyped.
Dr. Below, just for our edification, how long would that take?
I'm not certain about the consenting process or any need for sort of legal process around approving the particular tests to be run, but barring any delays from that, it usually has a turnaround time of a matter of days to a week.
Okay. And is that something that generally DNA testing facilities would do, to your knowledge?
Yes, so I'm not involved in sort of criminal DNA testing, so I'm not aware of all of the selection of platforms that might be available from those kinds of companies, but I can tell you that companies like Ancestry.com, 23andMe, Living DNA, they do this routinely.
Okay. Absent that, we now have tell the court again what your understanding is of the probability of relatedness. Absent additional.
Right, absent additional genetic information, correct. My understanding is that the probability of relatedness is 8.5%. The probability of these individuals having no biological relatedness whatsoever is 91.5%, and that this is reflecting the information derived from a handful, 29 genetic variants, and that per the website for this genetic testing company, this reflects the absolute lower threshold of what might be considered consistent with any sort of biological relatedness at all.
Quite frankly, is it below the threshold?
According to the website, they said that the range for exclusion was below 9%, and this is 8.5%, so yes.
Judge, I'd ask that her report be made an exhibit to her
I
testimony.
mark it as Exhibit 3.
Do you want me to give this to you now, or? Okay.
Judge, those are all the questions I have at this time.
Mr. Knowles, you may cross-examine.
Good morning.
My name's Marcus Knowles. I represent Miss Catherine Rundle in this matter. I just have a few questions. Do you agree that with the statement in the report that these results do not provide sufficient evidence to support or refute the tested relationship?
That comment is somewhat inconsistent with what was shown on the website. The likelihood of there being a biological relationship is reflected in that 8.5% chance.
But my question was, do you agree with that statement that this test does not provide sufficient information to say Miss Rundle is not the daughter of Charlie Mai?
Because the information is conflicting on that test report and on their website, it's hard for me to answer that question definitively.
Well, you have testified that there's a 1 in 11 chance that she is.
Biologically related, that's correct. That's what's
Biological.
indicated, yeah.
So 1 out of 11 times under this test, under this data, she is an heir. She is the child, the person, the relative, I guess is the word I'm looking for.
Yes.
Does it change the test any if the aunt and uncle were half siblings?
If the aunt and uncle were half siblings, I would expect a very different pattern of relatedness, yes.
Okay. So, for instance, I'll give you an example. The child that was tested is say a biological niece to one of the parties, but the other party shared a different father. Could that explain these results?
The question of whether or not the aunt and uncle are siblings would be something that the DNA testing company would be able to test very easily.
Did they, to your knowledge, did they test for that in this?
That looks like, to my knowledge, a test of the avuncular relationship between the niece and the aunt and uncle.
Okay, so back to my question, would that have changed these results?
Without knowing exactly how they've calculated those probabilities, I can't answer that question.
Okay. So I was looking through your report here, and you say that, do you have that in front of you?
Is it possible to have that back?
I think that's Exhibit 3. And I'm specifically looking at paragraph 2 on the second page.
Yes.
So I understand by that statement that you're saying, look, I can't independently verify this data, correct?
That's right. Without having the exact math that they use to calculate this combined probability index and also the frequencies of these variants, I'm not able to regenerate these scores myself independently.
So about the fourth line down in that paragraph, you say, in other words, the alleged relationship is not impossible given the observed data. This is consistent with the conclusions included in the report. So in that statement, you're saying it's possible that she is the niece related.
Given this data, it is possible, not likely.
So I don't know that I understand the report where it says the probability of relatedness was calculated by comparing the untested, unrelated random individuals in the Caucasian population, parenthesis, assuming prior probability equals 0.50, close parentheses. And you touched on that a minute ago, but I don't know that I understood what you're saying. So could you explain that again?
When we are doing likelihood calculations, we often start with a prior assumption of what the probability is of observing something. In this case, they've used a prior probability of observing this relationship as being 0.5, and then they have reduced that likelihood based on that.
So we started out at there was a 50-50 shot.
Yeah.
So 5 out of 10 times this child would be. And that's moved now to 1 out of 11.
That's right, at 10 to 1 odds, yeah.
So in this report, the best case we could have hoped for was a 50-50 shot?
No, because that prior could have been adjusted upwards to be a 100% chance.
So we just start not knowing, basically.
Right,
is what they're
exactly.
saying.
That's what they're
Okay,
saying.
that's fair. That makes sense. Earlier in your testimony, you were testifying about this 8.5% probability, and you said that's not far above what would be expected. What did you mean by that?
So I mean that any pair of people in this room are going to share many of these variants just because these variants are potentially very common in the population to observe. So you and I share 99.9% of our genomes. And so they have chosen specifically sites in the genome that are highly variable between individuals. And so, but even still, despite them being highly variable, they are common to observe. It would actually be disadvantageous to the testing company to test variants that are too rare, because then almost everybody would have the same genotype. So they've chosen things that are variants for their testing that are relatively common. All of the variants are relatively common. And so therefore, observing any one variant or several variants to be shared is not unexpected. And so what they've done is they've created a calculation by which they can look for excess sharing. And when you are testing a relationship that is avuncular, there's a wider band around that relationship of how much sharing you might observe to see, because there's multiple inheritances of the DNA segments. And that biological variance around that expected mean proportion can result in there being some sort of noise on the estimate. And that is why they are, unlike paternity testing, where you would get complete 100% discrimination in every case, with the exception of like damaged DNA. In this case, you would expect to see that there's some likelihood of sharing that is just by chance, in addition to the likelihood of sharing that is due to relatedness.
That likelihood by chance, wouldn't that have came back as a 0 though?
So it's not uncommon at all to see random individuals from a population to share slightly more genetic variants or slightly fewer genetic variants. And so this is saying that there's a 91.5% chance that the amount of sharing that is seen here is not above expectation for any two random people that would be drawn from the population. And they're saying that the chance of there being a biological relationship is 8.5%.
So it is 8.5% above what they expect for random people.
No, that's not what that is saying.
But
Yeah.
if it's 91% below what they would expect for a conclusive relatedness,
It's-
why would it not be 8.5% above what random people would have?
Yeah, so you could imagine that the,
I know it's hard explaining to somebody
Yeah.
that don't understand.
yeah, and I'm about to start drawing figures with my hands, but like, if you imagine that there's some distribution of the expected amount of sharing that people have by chance, and then you have the expected amount of sharing that you would see if there was an avuncular relationship, there's an area where those tails cross a tiny bit. And so we are in that area where it's a 91% chance that this would be seen in an unrelated case, but there's a tiny bit of that tail of the distribution on the very, very low end of sharing between an avuncular relationship. And so it's falling in that little corner where those two distributions meet. But the threshold there is so low that it is at the absolute tail end of having a likelihood of, or being a likelihood that is associated with an exclusion. Per their website, they say anything below 9% is considered not biologically related.
But you don't have any knowledge of why they put that these results do not provide sufficient evidence to support or refute the instant relationship.
I mean, I would be guessing. It's possible that they rounded the number, and 8.5 rounds to 9, and so that put that in the 9 to 85% chance that they say is inconclusive, but that would be a guess.
So, of course, the purpose of the court here, the last thing the court wants to do is exclude someone that should be included. And your advice in your letter or your additional options.
I appreciate you speaking on my intention of what I want or don't want, Mr. Knowles.
Sorry, Judge. Would your proposed testing, this additional testing, would that give the court more clarity?
Oh, I believe so, yes.
Would it, in your opinion, would that come to some form of absolute certainty as to genetic relatedness?
Yes.
Now, would that, your additional testing, would that also test the alleged aunt and uncle to determine if they were actually true siblings?
If you had me do this, I would absolutely test all of those relationships, yes.
Do you do testing?
I look at pedigrees like this and reconstruct them from genetic data, I mean, every day of the week. This is my bread and butter at work. I have never done that for a court case before. I've offered that if, and I believe I wrote that in here, that if the genetic data were produced, I'd be happy to look at it myself to verify.
So, one last question here, or chain of questions. The actual father of my client, Kathy Roan, if he was a half-sibling to Janie Might and Willie Might, the two people tested, would the results that you would provide us, would they show that? Meaning they all share the same mother, they all share the same father.
Yeah, in that case, I would expect half avuncular relationship, and that is something that would be testable.
Good deal.
So an avuncular relationship is considered a second-degree relationship. Parent, offspring, full sibling, those are first-degree relationships. Half-sibling, avuncular, grandparental, those are all second-degree relationships. And half avuncular, cousin, great-grandparental, those are all third-degree relationships. And the tools that we use every day in my field of work can discriminate between a second and third-degree relationship very, very readily.
So there is a way to get that certainty without exhuming a body or
Yeah.
testing. Okay, thank you.
Ms. Roberts?
Get the old sample that was used by the lab and provide that to you, or we get new samples. You could run and as you say, if we didn't use outdated court stuff and we used the new protocol.
If you were to pay a company to generate the genetic data and submit the DNA specimens to that company, if you then provided, whether those were the old specimens that were sent to DDC or if they were newly acquired spit or blood samples, whatever genetic data samples, then I would be able to verify.
You want so if you look over in your report, if you've got it, figure 1, which is this graph.
Yeah, that's the pedigree, the
That is.
family tree as was to represent the relationships that were being tested.
Okay. So if we got that company to run additional data and they
Yes.
provided that data to you, you could extrapolate from that.
Yes.
Is that what we're saying?
I don't know if DDC offers that service. I would be happy to put together do a little bit of research and try to propose companies that could create that more dense DNA information.
Because again, their testing, as I understand it, this avuncular testing, aunt and uncle, niece, nephew testing, and you keep saying their website says the 90-10 variant there. You're saying that if we can get additional data and that we could then almost come up with a guarantee, if you would, whether there is a avuncular relationship, correct?
Yes.
Because what we're using is really outdated.
It's fantastic if what you're trying to do is match a DNA sample to a particular person, so you're looking for identity. It's also really fantastic if what you're trying to do is match a person to their parent. But
That's not what we're trying to do.
that's not what you're trying to do here.
And so again, like I said, when I'm looking at this profile or what we're talking about, which is figure A, you've got 2 women tested with both X and X chromosomes, and you've got the male tested who is X and Y chromosome, right?
That's correct. They're labeled as the child, the alleged aunt, and the alleged uncle.
Okay, but then when you compare the alleged aunt and uncle, and again, this is, y'all are talking, in your professorship, y'all are at a 400 level class, and I'm still at 101, okay? So if you're looking at it, comparing,
I didn't even get into class.
when I'm looking at it, as I said, the A1 test, the X chromosome, the A2's testing an X chromosome with the females and the A2 is the Y chromosome with the male?
No, I'm sorry. So the A1 and A2 are representing the genotypes that were inherited from the maternal and paternal chromosomes. So you have, in the human genome, there are 22 autosomal chromosomes and then the sex chromosomes. And each autosomal chromosome is inherited, one from your mother and one from your father. So that means that at every one of these, and the first column that is identifying the genetic marker, the
Right.
name of the marker, at each one of those markers, you would expect to see one marker that was inherited from mom and one marker that was inherited from dad. And so when there's only one number in the DNA test report, here I've extrapolated it to show it twice because that's indicative that they only observed one variant, means that it's homozygous. They inherited the same thing from their mom and from their dad. When you see two different ones, they've inherited one from the mother and one from the father.
So that's under A1.
So A1
You've
is,
got 14 under A1 for child, 15 under A1 for aunt, and 18 for A1 under uncle.
that's right. So that means that the child has a genotype of 14/15. So the child inherited 14 copies of this piece of DNA from one parent and 15 copies of this piece of DNA from the other parent. The alleged aunt inherited 15 copies of this piece of DNA from one parent and 18 copies from the other parent. And the alleged uncle inherited 18 copies from both parents.
So the fact that the alleged aunt and the alleged uncle didn't match.
The alleged aunt and alleged uncle both match because they have an 18.
So just one is a match.
Just one is a match. And the expectation in siblings is that 25% of the genome is going to match on one of the two variants that's inherited. 25% of the genome is going to match on neither. And 50%, I'm sorry, I said that wrong. 25% is going to match on both. 25 is going to match on neither. And 50% is going to match on one. And
Okay.
that is the proportion that's expected to be shared due to their relatedness.
Okay.
And so that doesn't take into account sharing that's due to just the
Common-
random chance. Yes.
Commonality of
Yes.
population.
Yes.
Okay. So in looking at that, that's how you extrapolate, like I said, aunt on the third one down, D16S539.
Yes.
Aunt and child match on A1s. Uncle and child on A2.
Correct. And that's one of the reasons
And that's where
why,
it says potential match, because it's not under the same A1 and A2.
so the reason why I highlighted that one of interest to me was because the child is only potentially inheriting one of those two from their father and from the same grandparents. And so I noted that because I'm not certain how the genetic testing company was scoring this, and I was concerned that if they were counting that as a match on the 9 variant and a match on the 11 variant, they're overcounting. This would cause them to overestimate the likelihood of relatedness. So that would suggest that 8.5% chance might be a little high, and that it should be in fact lower.
So, but at any rate, there's testing, an algorithm, whatever the expertise you've got. We can take what we've got,
The DNA specimens
the
that you
DNA
have.
specimens that we have right now, if they're still in existence. I
Yes.
don't know how they store them.
Right.
But if they're still in existence, you can give us what needs to be run on that.
Yes, I might be able to advise some options.
And then we can get that, and then that will give you more of an insight from your expertise to say, this is not a child or this is a child.
Yes, if I had dense genetic data, I would be able to determine this.
Dense genetic data.
Yes, I would be able to determine this with very high levels of certainty.
And whether or not that the samples that we have now, if they still exist, we should be able to get that information you need, or we may have to get new samples to run the information you need.
That's correct. I don't know anything about the
Yeah, I don't
state
need.
or quality of those, yeah. Okay,
Thank you, ma'am, appreciate it.
yeah, no problem.
So, I'm impressed. You know your stuff. I appreciate your expertise. You're highly qualified. Tell me how is the best way that I can make this determination based on DNA? If I was coming to you today and I was going to say, Dr. Below, I have a lady who says that she is the child of a deceased brother. I have a brother and a sister and another brother who are still living. How do I get a determination by DNA whether or not this lady who says she's related is actually related? Start fresh. Tell me what I need to do.
Yeah, if the data that we have here is the only data
Don't
available.
disregard the prior data.
Okay,
I'm talking
disregard,
about
okay.
If I came to you today, just disregard what we've done. If I came to you today and I said, this is what I'm trying to determine,
Mm-hmm.
then what would you recommend?
I would recommend genotyping the samples on a very dense genetic array and providing the data to an expert like myself or someone with similar expertise who would be able to give you very, very high confidence of what the
Now,
relationship type
Would you
specifically
want the
is.
third sibling that's still living? We got a brother, a sister, and a third one who hasn't been tested, in addition to the lady who's claiming it. Would you think that all three of those men, the two brothers and the sister, and the lady claiming to be the child of the deceased brother, should all be tested?
I am a scientist and specifically a data scientist.
I'm
And
not.
so the more data, the better, in my opinion.
Well, that's what
But yeah.
Ancestry.com keeps telling me. The more that my family they test,
The more of
better.
your family they test, the more that they can get resolution on it. So I would argue that the tools that we have at our disposal to be able to test for avuncular relationships are highly discriminatory when used on dense genetic data. And so I wouldn't require additional DNA samples to be collected in order to be able to make a very accurate determination about the relationship between, in my drawing, H and E and F. But with that said, the more data, the better. So for example, having genotype data from individual C, so the mother of the child who is the alleged niece and nephew, could potentially be informative, as well as any other siblings of E and F that are available.
All right, now, let's back up, and now considering the fact that we've had DNA testing, you've got a copy of the report.
Yes.
What would you need additionally to be able to extrapolate that out and be able to give us the definitive answer? What would you need from this DDC DNA Diagnostic Center?
So, given this test report, the probability that the child and the alleged aunt and uncle are related is low, and in fact is right at the cusp of what their company is reporting, given their statistics, and they know what the commonalities of these variants and these different alleles are in the population. So they have been able to determine that a sharing percentage that's observed, what the likelihood is of relatedness. They've defined a relatedness threshold, and this is sitting right at that threshold. And so if I were to interpret this, I would say that the likelihood is very high that these individuals are unrelated.
Well, I have before me testimony from family members who identify, I have a birth certificate with this lady's name on it, and the father, Charlie, who is deceased, as being the father of this Miss Rundle, who is the claimant. I have the testimony of one of the people who were tested, that she knew this was his child, that he affirmed it was his child, and that this is something generationally handed down. That information has been given to me. So I have the information saying, this is his daughter. We believe it's his daughter. At least that witness said that. He believed it was his daughter, according to this witness. And then, does that information, when we talk about random and whether this familial relationship being random or whether it isn't, would that information be relevant in the consideration of whether or not this is a random connection DNA or whether it's actually a biological connection? You understand my question?
Yeah, I understand your question. I think that the complex family trees are what I deal with every day when we have families that are concerned about transmitting illness to their children. And so it is not uncommon for us to have to reconstruct a family tree based on the genetic data rather than based on what the report is from the family about their relatedness. We oftentimes observe cases of non-paternity. We oftentimes observe sample swaps and handling errors, things like that. And we use the genetic data regularly to be able to correct those errors in the pedigree so that we can provide families with the best information as possible about their child's risk of disease.
And perhaps I
And-
misunderstood. I'm sorry for interrupting you. You finished.
Yes, so I think that if you have conflicting information and you would like the genetics to resolve that conflicting information, if this probability that's shown in this report does not meet your sort of need for it being conclusive, then doing the additional, more dense genetic testing would, I think, get you to the confidence level that you want.
And that's where I guess I'm coming from. I've got to make a decision. This is an estate that this is not a minor issue.
Right.
Theoretically, there's $250,000 at stake for, if I recall correctly, for everybody involved in this situation, depending on how I rule. So my intent, and not only that, but it's also the establishment of a familial relationship for a lady who has been excluded from a family that she thinks is her own. So it carries with it not only moral, ethical, and, just personal, but it also has monetary value that we're talking about. So I want to do this right. I want to get the right answer. And
Understood.
I'm looking to you to help me get to that right answer. So my question, I guess, circling back to it is, you have this report. What do you need if I authorize this to be submitted to you for additional testing? Can you do that, first of all?
I do not have a machine on which I could generate the genetic data.
All right.
That's not what I do. I'm a data scientist who analyzes genetic data.
So what would you need to have generated for you to make this extrapolation?
Yeah, it could be any number of platforms of dense genetic data, and I would be happy to provide a list to the court of sources by which you could acquire such dense genetic data. And if that data was acquired, I would be able to both look at the proportion of the variants in the genome that are shared and use the more sophisticated and narrowing down approach of looking at the length and the distribution of the segments of the genome that are shared contiguously throughout the genome to be able to make a determination of whether this relationship looks like second degree, third degree, or unrelated.
All right. So samples, if those samples that were taken originally of the three individuals, Ms. Rundle, Ms. Janie Myatt, and Mr. Willie Sam Myatt, if those samples are still in existence, is that sufficient for you to make that determination if it's submitted to this other agency that you're saying for a genetic breakdown?
Yeah, so if a company, and I'd be happy again to try to compile a list of sort of fee-for-service genetic testing companies that would be able to provide dense genetic data files to me, or to the court, and you could choose your own geneticist. But somebody with my expertise would be able to then use that genetic data to make this determination very, very efficiently.
Okay. Anybody got anything else? Have I sufficiently confused everybody? All right, but you are willing to assist the court in making that extrapolation. I keep calling it an extrapolation, whether that's the right word or
That's
not.
okay.
But in
I give you all
making-
A's, by the way.
Do what now?
As your professor, I give you all A's today.
But you're willing to assist the court if we get this information to you, then you can make that determination.
Yes, I'd be happy
And
to.
you're thinking it's a probable 100% determination.
I would be able to do it with very high confidence, yes.
Right. Thank you, then you can step down.
Would you like this back?
Oh, y'all all know where I'm headed with this because, you know,
Have a high confidence idea.
I don't believe that.
you think they don't have it still. I could be surprised if they did. I don't, as many as probably they do. All right, well, let's do this. I'm of the opinion what we need to do is just retest everybody. And let's go ahead and test Ms. Franklin's client as well, because more DNA, the better, right? Is he subject to where you could get a sample from him?
I had done some other stuff.
Who has the power of attorney?
All mine.
Okay. Well, this case has been pending a long time, and I would like to bring it to a conclusion. And the issue that we're dealing with is the only thing that I think is keeping it open. So and as you heard me tell Dr. below, I want to make the right decision. I want to make sure that everyone is satisfied that these are in fact the facts. So for that reason, I'm going to authorize us to, if the original DNA samples for the 3 that were tested are no longer in existence, which I fully expect that to be the case, then we're going to retest. Let's just go ahead and retest. And if we can get another test of him, that's not absolute, but I'm ordering if it's possible to get that as well. I want to get this done within the next, I don't know, is there any reason we can't do that within 15 days? Send it to, let's get Dr. Below to give us the name of a geneticist to submit that testing to. And then once that geneticist has performed the testing, then make sure that Dr. Below has whatever information she needs to do what I keep referring to as an extrapolation. And then we'll get that report, her report will be submitted to all the parties. I think Dr. Below says the more the merrier, the more the better. But I don't want to prolong this situation by adding additional people if the essentials. But anybody that wants to contribute their DNA, then by all means, we'll certainly allow that to happen. But we need to get, number one, the name of a geneticist who can, that we can draw the samples and make sure that it's done correctly, have the geneticist supply Dr. Below with everything she needs, and then get that done within a reasonable period of time, and then Dr. Below, you'll be authorized by the court to perform your calculations and make a report back that report will be available to all the parties and to the court. Anything I'm not addressing in that particular regard? Well, she submitted a DNA sample before. I mean, as we said, you can get a sample through the mail and go from there. Yeah, I mean, find it out. You know where I'm going to be for the rest of this month if we have to address this issue. I want those samples submitted. If there are existing samples that can be submitted to now, Dr. Below, you can just answer this question. Would there be a degradation of the DNA if the samples were adequately preserved at this DDC? All right. Would it be better if we just did new DNA samples? I'm sorry. Well, let's find out if they're still in existence, and if they are, we'll use those. If not, then we'll get new samples from them and everything.
I don't know if it's a phlebotomist.
I'd rather, If it's already in existence, it'll expedite it, so let's try that first. All right. Somebody needs to draw an order that says that the judge in his confusion over DNA is ordering that the additional testing be done, so.
I would nominate
Mr. Vandervoort, you'll draw the order. All right. Thank you. Ma'am?
Yes, I am a niece of Richard,
Okay.
and I've just got a question about the personal assets that was in his house, pictures and all that, and maybe some money that he had in an account. When is that going to be distributed?
The executor of that
The executor
estate
is Odell.
is Mr. Odell. That is a question that I would suggest Mr. Odell needs to address.
Judge, on the morning of the sale of the real property, I asked Mr. Neil Trice to remove the very personal items that were owned by Mr. Myatt from the auction, and he delivered those to my office, and they've been safe kept. They consist of greeting cards,
2 years?
photographs, things of that nature, Judge. There's been discussions on what to do with it. It's all still there. I was going to file a motion, set on the 28th, ask the court for instruction.
Well, file a motion
Anything I
and
do-
let us get it addressed so that hopefully we can take care of that issue as soon as possible. We have court dates the rest of this, there's one later in the month. We may be able to address it later this month.
And Judge, as far as the remaining cash, it's about $213,000. It's sitting in a bank account at First Federal. I don't think it can be dispersed until the court determines the airship issue.
All right. What I'm saying is that file your motion to require instructions on what to do with the personal property and let everybody be noticed in. It's not just easy where I can say, we'll do this. We got to give everybody an
Well,
opportunity to be heard.
it's been 2 years, and I was just wondering when it was going to
Well,
be.
we'll get it set for a hearing later this month, and if you'll file your motion.
All right, thank you, sir.
All right.